Hello everybody, I am Dr. Bharti. I am working as an Assistant Professor of Law at National Law University, Delhi. Today I will be discussing a module on barriers to access to justice. The objective of this module is to understand various barriers to access to justice, how it adversely affects the access to justice, and how is it adversely affecting the society at large. At last, we will also look into that how we can remove this barrier and secure access to justice to people. In the opening lines of the preamble to the Constitution of India, the sole power has been vested into the hands of we, the people of India, and have guaranteed to ourselves justice, social, economic and political. Justice within its ambit consists of many rights, the denial of which results into the violation of fundamental philosophy of the Constitution, which is to secure the rights to the citizen. Access to justice is therefore a commitment to ensure that the people have a right to have their grievances redressed and a right to pursue their legal remedies, either in court proceeding or other informal proceeding, so as to ensure that their rights are protected. Impediments to access to justice. There are certain impediments to access to justice which, despite of having sufficient legislation for protection of right, debars a person from justice. Impediments to access to justice can broadly be categorized into two categories. Firstly, social and economic barrier, and secondly, legal barriers. To start with, we'll discuss social barriers. What are those social barriers which restrain a person from reaching the court of law and redressing their dispute and availing the justice which is their right? Social barriers are those impediments which arise by virtue of the social setting in which the person resides or has grown up or nurtured in. When the very society in which the person resides becomes the impediment in voicing his opinion, this leads to defeat of justice. India has always been a mix of two societies, India and Bharat. Bharat resides in villages which are heavily dominated by class politics and caste dynamics. Access to basic amenities are the biggest challenge of the days, which in turn resulted from the class divide. The rich grew richer, whereas the poor were oppressed and not given the basic amenities such as proper education, a healthy and balanced diet, as well as a way to enhance their skill so that they could grow as a human potential. It was on account of these systems that a feudalist society came into being. In India, the position of the poor was further marginalized because of the caste system, where they were treated as sevaks. It was by virtue of the social stigma that they were not allowed access to villages. For them, they had separate way to enter the villages and were not allowed to draw the water from the water bodies which were used by the masters. Furthermore, people from the lower caste were not asked to be a part of any religious ceremonies or proceeding and were not invited or given a chance to represent the local bodies. They were denied the right to hold properties and were enslaved into working for their masters. This psychological treatment was internalized by these people for centuries, and the change in rule only meant a set of new masters, for everything else was the same. It was on account of all these factors that they were denied the right to access to justice. In the later years, due to the inception of this caste divide, access to justice became all the more difficult. With the advent of colonial rule, separate court of Fort Williams and Calcutta were established. There were separate adjudicatory processes established which governed the indigenous population as well as the British people. For the Dalits, however, no forum of grievance was ever available. Denial of social justice to indigents was one of the reasons for lack of faith in the justice administration system. If an accused was a Dalit, he was forcibly tried, but if he happens to be a complainant, the story was entirely the opposite way. The other reason which were responsible for the complete deterioration of these conditions was Jamindari and Rayatwari system, which compelled the villagers to work on their own lands in the capacity of bonded laborers and were often denied even the basic food for their own subsistence. Multiplicity of taxes depending upon one's caste was another reason why they were heavily indebted and had to rely on the grants of their master and jamindars. Now the next point we need to discuss is what were the steps which were taken by the state to remove these social barriers. We have understood the reason behind the existence of social barriers and how they were affecting the people from reaching the court and in getting the dispute redress and achieving the justice and availing the rights which is granted to them by law. To know how these barriers have been removed and what are the steps taken by the state to remove these barriers, we need to know the following thing. First, post-independence, the system continuously and steadily improved. The series of changes brought by the First Amendment Act delivered the promise which the welfare state held and brought to the farmers the right to hold property and acquire own property. The directive principle of the state policy guaranteed to them the right to equal pay to equal work and commitment to ensure just and human condition of work. Furthermore, by virtue of the mixed legislative enactments along with the judicial activism, new rights were read into the right to life, such as right to earn livelihood and the right to health and well-being, the right to basic standard of living and dignity at workplace, and the right to free medication, which defined the new India. Taking a serious view of the caste divide, the Constitution explicitly forbade the archaic practice of untouchability and made it a criminal offence. By virtue of the social strata that the people came from, early child marriages were rampant and corrupt practices such as dowry and ban on widow remarriages had led to serious deterioration of the society. Measures to curb such social evils were started by joint efforts of Sir Williams, Swami Dayanand Saraswati, Swami Vivekanand and Raja Ram Mohan Roy. Furthermore, by virtue of the lack of access to education, the people were not even made aware of their rights that are constitutionally sanctioned to them. It is because of this lack of awareness brought about by dearth of primary education that most of the people are forced to live in the lives of labor and servitude. Most of the worker and their family members are often perturbed by the idea of education, even though it is a fundamental right constitutionally guaranteed under Article 21A of the Constitution. The conventional idea was to send the children to work so that they could earn money and support the family. A most glaring example of the effect of social divide is evidenced in the criminal courts. Safeguarding the protection of interest of people were duly incorporated under the Code of Criminal Procedure 1973. It is a fundamental tenet of the criminal law that every man is deemed to be innocent until he has been proved guilty. Provisions such as completion of investigation within sufficient time mentioned in the code itself were made to ensure that the person were not made to undergo the rigors of incarceration over and beyond the requisite period of detention authorized under the law. However, the present population and demographical analysis and under trial prison statistics shows that almost 75% of the under trials are those who belongs to the weaker section of the society and therefore have limited or no access to justice. Moreover, the acute problem of awareness has escalated this ratio to measure proposition, which has further eroded the concept of access to justice. After understanding the social barriers, its impact on society and how it is adversely affecting the inter-society, we are moving ahead to know what are the economic barriers which act as a barrier to access to justice, how does they exist in our society and how they stop people from reaching court and getting their dispute redressed. Another very important impediment is the division of society due to economic factors. Access to justice has never been a problem for one who has access to all means and financially sound. Access to justice is a difficulty for someone who has no resource to financial resources and therefore had no resources to pursue legal remedies, assuming that he was in fact unaware about his rights. There were various informal modes of dispute resolution which were and are in existence in the country and have done a phenomenal role in bringing an end to the disputes, thereby bringing justice to the very doorstep of these litigants. Yet by virtue of the prevailing class divide and the all-pervasive domination coupled with the class politics and the blatant misuse of power, the poor are left remediless. Corruption has made the impact of economic barriers more grave. Various public offices work on corruption and bribery, thereby making access to justice a difficult and unachievable reality. Corruption has been internalized at all levels, from getting a copy of judgment to filing of an application or to pray for an adjournment. Corruption therefore is and continues to be one of the gravest hindrances in the administration of justice. Lack of awareness about informal mode of access of justice as well as about the ongoing work of the Legal Service Authorities Act is one of the major reasons that such impediments still exist. Furthermore, the lack of knowledge takes away the right of an indigent to make use of the beneficial provisions. In cases of criminal nature, the complainant or the aggrieved is mostly unrepresented, and his task is limited to that of a spectator after his testimony has been recorded by the court. Due to lack of awareness, indigenous rarely file protest applications if the police decide to drop off all the charges against the accused. The lack of knowledge and awareness of the court proceeding as well as general fear of the court system create a gap between the poor and the state enforcement agencies. In various cases, the advocates which are engaged under the legal aid schemes are incompetent or do not spend sufficient time to adopt a responsibility towards the client assigned to them. After understanding various social and economic barriers and how they adversely affect the interests of people and act as the barriers to access justice, we will move ahead to understand what are the legal barriers to access to justice. In this segment, focus will be on the issues of barriers to access to justice which can be attributable to the system in which we operate. People are unable to obtain remedies because of the various reasons which may or may not be attributable to the society in which they live, but because of the system from which they seek justice. The problems are manifold. However, an attempt has been drawn to look at the justice dispensation problems from the viewpoint of three very crucial stakeholders, that is the litigant, court and the police. Existing lack of resources, mounting backlogs and mismanagement accounts for the biggest procedural causes of delay in the criminal justice system. Internal management system still has a very little or no reliance on computers and modern modes of communication. In the context of the court, the litigant has to bear long delays right from the stage of filing their complaint or plaints till the disposal of cases. One of such legal impediment to access to justice is related to service of notice. The problem which causes the maximum amount of delay is the service of notice to the other party. The system of process of issue, either through court or through dasti, causes major concern to the parties, right from the stage of identifying where the disputant lives to bringing their legal heirs on record in case of one or more of the parties are dead or have been incapacitated to contest any further. With specific reference to criminal adjudication, the process becomes even more tedious. In order to call a witness to depose his or her statement, thereby compelling a witness appearance before the court, elaborate procedure have been provided under the Code of Criminal Procedure 1973. At the time of recording of evidence, the presence of accused is mandatory unless otherwise provided under the provision of the Code of Criminal Procedure, which can exempt the personal appearance of the accused before the court. In other category of cases, unless and until following people are present, the witness cannot depose his statement, and these people are the judge, the accused, the public prosecutor and the defense counsel. And many times it becomes difficult to collect all these people at one point of time and get the statement of witness recorded, which causes further delay. More often than not, witness absent himself during the court proceeding either knowingly or otherwise. Sometimes because of the pendency proceeding, the witness changes his address, but when the case is called upon, the witness is no longer available at the address given by him at the time of investigation, and thereby the witness become untraceable. The very criminal procedure that initiate proceeding by first issuing summons and subsequently issue of a bailable and a non-bailable warrant before proclaiming the witness as an absconder and attaching his property or issuing a standing warrant against him. Another legal barrier which causes hindrance in the path of access to justice is related to police stations. The police stations, which are entrusted with the protection of the people, maintenance of law and order, investigation of offences, are also entrusted with the task of securing public places, providing security cover to the dignitaries, and conduct witness protection program as well. According to the elaborate guidelines rendered by the Honorable Supreme Court of India in the case of Prakash Singh versus Union of India, has unequivocally expressed its anguish at the state of affair and the nature of the job, which has not only demoralized the police force but also which is also very disinsensitizing. The police manual, which regulate the practice, procedure, role, function and responsibilities of the police officer, are archaic and need systematic improvement, which are to be kept for a long period of time. The salaries need to be periodically revised and the job need to be made more insensitizing in order to attract the best human potential. The multiplicity of tasks was further frowned upon by both the Law Commission of India as well as Malimat Committee report on criminal justice administration. There are few attempts made to provide a refresher courses to the police officer or to review their physical fitness. Every police station has to maintain many register like daily register, which is maintained to keep minute-to-minute track, register of inventory of all the weapon holder including their licensing number, year of expiry, crime register, offender register, other register for summons and warrants which are to be handed over in their jurisdiction, seizure register and many more. With grossly understaffed police station, on any given day, there are at least 3 people who spend their entire time in making entries in such registers. Other officers are to be divided for the host of other duties. There are 2 more officers whose task is to visit the court every day and take the list of the warrants and summons which are to be delivered in their local jurisdiction on day-to-day basis. There were steps to initiate technological interference in every such police station, but because of the low education level of the police constables and the computers have been lying in dust for sufficient period of time. Another legal barrier is connected to forensic science assistance. Court take assistance of forensic science to get the best evidence. With specific reference to criminal adjudication system, it takes years to procure an investigation report or a medical report or a forensic science laboratory report. Due to the severe resource crunch, there is no FSL unit in many districts, because of which in heinous offences, most of the records have to travel all the way to the state or divisional headquarters, which are already reeling under many other similar cases. Often because of this delay, material evidence is lost or destroyed or becomes adulterated or inconclusive, which gives an easy way out to an accused person. The agencies are well conversant with all the flaws that have been existing, but lack of political or administrative will has led to the lapse of the system, and the ultimate loser is the victim. Another legal barrier is related to the court process. It is the prominent principle of law that there has to be finality to litigation and the dispute between the parties should get some logical conclusion. The laws of this great nation provide for effective adjudicatory systems. The laws of this great nation provides for effective adjudicatory safeguards at every step so as to ensure that the end of justice are met. However, these procedures on almost a regular basis are flaunted and misused, thereby creating a situation of docket explosion. Many a times, parties resort to interlocutory application against which ordinarily no power to appeal or revision lies. Yet, in all such categories of cases, and especially in criminal matters, the lawyers, by virtue of their skills and innovation, grossly misuse the process of the court by way of these interlocutory application, causing delay ranging from months to years. Framing of issue seems to be another long-drawn procedural step. At this stage, either Order 14 of Civil Procedure Code or during a criminal trial, the power vested in the court is absolute, in the sense that they can frame an issue at any stage during the trial, which include right before the judgment it is produced. The parties are therefore at complete liberty to assail averments after averments at any stage of the trial, which can then be treated as a separate issue involving a question of fact or law or both, and which will then operate irrespective of the state at which the trial might have reached. Another legal barrier is related to the advocates and their conduct in the court. A lack of legal knowledge in substantive as well as procedural law on the part of advocate actually adversely affect the interests of the client whom they are representing before the court of law. Advocates sometimes do not prepare case fact well, which reflects in their pleading, as they remain clueless when judge put question to them. Most of the time, advocates are single-handedly the most worrisome cause of litigation. Advocates are often seen running between the courtrooms because they are involved and engaged in many cases, and hence they ask for adjournments. Frequent and unavoidable adjournments due to the tactics of litigant and their lawyers are major cause of delay in the court. The state of affairs at the legal aid advocate is pitiable. The lawyers are not insensitized and are asked to represent the clients who are never in a position to bear the expensive. Huge number of such cases and a fewer number of advocates to represent their case before the court had made the constitutional commitment of providing free and compulsory legal aid very difficult, which has not only been provided in the Constitution of India but has also been time and again declared by the Honorable Supreme Court in many cases like Hussain Ara Khatun versus State. Now we need to understand that how these barriers can be removed, and if any step have been taken by the state, what are they and how they have actually helped the litigant in achieving the access to justice. Various schemes have been launched to ensure that justice is actually made available to people, with the inception and focus on the alternate mode of dispute resolution, and by taking recourse to the ancient form of dispute resolution such as Panchayata, Lok Adalat and Gram Nyayalas, a serious attempt have been made to eradicate the system of court pendency and backlog of cases. The Supreme Court of India has too, as a protector and guarantor of constitution provision, has repeatedly stressed that right to free and compulsory legal aid mentioned and provided under Article 39A is a serious commitment to ensure that justice is not only done but it is also manifestly seen to be done. In a series of cases, the Supreme Court of India has held that an attempt should be made to eliminate disputed right in its inception, so that poor families are saved from the ordeals of trial. Furthermore, through the formation of committee on the implementation of legal aid scheme and the subsequent enactment of the Legal Services Authorities Act 1987, lakhs of indigents have been brought closer to justice. Realizing the need to put an end to the instances of forced labor and bonded labor system, the Supreme Court of India, in the case of Bandhu Mukti Morcha versus Union of India, categorically exposited the right to a dignified life to all the workers who are in unorganized sector and have been physically and mentally exploited over the years. The legislature too has shown laudable attempt to preserve and restore the dignity of those who were known as Harijans and have been oppressed from centuries. The Prevention of Atrocities to SC/ST Act is a welcome change, along with the Prohibition of Untouchability Offence Act 1955. It provides for setting up a special court for cases falling under such acts. It also provides for special training and sensitization of officer and staff of such courts so that they could impart justice in the same spirit in which it is provided by the provision of such acts. With countless awareness programs being introduced through telephonic, electronic and print media, the people are being made aware about their rights and how to enforce a remedy in case there is any threat to such right. The Ministry of Law and Justice has also organized many campaigns, awareness programs to make people aware of their rights, and if their rights have been violated, how they can protect their rights and how they can secure access to justice. Furthermore, the government has also taken steps to educate people about the informal modes of dispute resolution, such as the pre-trial mediation, negotiation or judicial settlement. For petty trifles, reference to Lok Adalat and the Gram Panchayat has become a routine. The National Informatics Center is committed to bring about new technological advancement so as to eliminate the tedious number of visits of a litigant once his case has been listed. The police station too have started the digitalization drive to do away with the copious amount of paperwork involved in preparing 27 registers and to only focus on the task at hand and solving the crime. Despite of many steps taken by government to eradicate this social, economic and legal barrier, still there are many barriers which are standing in the path of access to justice. We are in need of increasing the number of legal aid advocates so that they could provide quality justice, so that they could provide quality assistance to the client assigned to them. There is also need of increasing in court numbers and the investigating agency staff. In addition to this, there is a need to work on the improvement of infrastructure. Attempts and efforts should be made to introduce e-court system in all the courts in India. This is beneficial not only for the court working but also for the litigants and investigating agency, as it saves time and very easily accessible, and at the same time it preserves the data for a long time. So an attempt should be made to improve the existing infrastructure, and infrastructure which is litigant friendly should be provided, which will actually help in achieving the access to justice in a better way. In addition to all this, periodical training of judges, court staff, advocate and the police for updating their knowledge and sensitizing them towards the problem should be conducted on periodical basis. To conclude, I would like to say that lack of faith in the existing judicial system has led to the establishment and constitution of Khap Panchayat, which is against the access to justice principle. To conclude, I would like to say that lack of faith in the existing justice delivery system has led to social communities to take a firm step and form their own courts called Khap Panchayat, which resulted into large-scale human rights violation. A specific ethic code is to be abided by all the members of the society, or the sanction imposed has to be enforced against the erring member. Most of the laws are openly flaunted. Most of the laws are still openly flaunted, and access to justice remains a distant dream for most of such individuals. There are various ways in which access to justice is being achieved at every level, yet India is at a stage where it needs to carve out an effective and achievable policy which speeds up the process of dispensing of justice. Thank you.